Welcome to the Public Opinion Court, where the truth ain't reality, but opinions are. Listen, y'all, it feels so good to be back and trying to get back into the groove of things. I have left y'all on red for a little bit, more so because I've been preparing for some projects and preparing for some cases. So your girl been working. I've been working. However, I'm back because I have the breakdown and the shakedown of Bad Boys Finance. The people like Bad Boy has been fighting, like old, new, current, you name it, they've been fighting. So I had to come back and bless you all with a breakdown. So before I get started, listen, make sure you are liking and subscribing to the page because I am close to my goal of 500 subscribers. And I know that y'all can get me there. And I know y'all love me and I know y'all love to hear from me. But yeah, so if y'all can make sure y'all are liking and subscribing and sharing this live, okay? Now, let's go ahead and get into it because Diddy has gone back to the judge for, this is the fourth bond setting. You know, he had those two last year. He had the one right after the partial acquittal. And now he's back again. Let me tell you the risk that he's running. Like you do not want to piss the judge off because the judge clearly stated at the bond hearing at not even a month ago, sir, you are a danger. You will take flight. I don't trust you. So no, you're going to sit back there until you get released. So that's essentially where the judge left off at. And I'm like, are you going back before this judge? And this is the one that got to sentence you, the one that you want to bypass the sentencing guidelines to let you walk? I think you're making a mistake here, Mr. P. Diddy, Diddler, the rubber. So let's get into the bond that, hold on, let me make sure. So he filed this motion. Let me make sure that. So Diddy filed this motion on the behalf of his attorneys. And we're going to, of course, break it down. So with that, let's go ahead and read it. Sean Combs, through his counsel, moves for his release on appropriate conditions in advance of his sentencing hearing, scheduled on October 3rd, 2025. Hold on. There are exceptional circumstances warranting a departure from the mandatory detention and ensuring that Sean Combs is released. What are the special circumstances, sir? None. First, as shown below, the history of the MANN Act, well as how it has been prosecuted over the last several decades, clearly indicate the exceptional, indeed unique nature of the case, specifically the prosecution and continued incarceration of a customer service provider by a sex worker to a third person, rather than a defendant profiting financially from the business of prostitution. In the limited cases of the MANN Act, convictions from across the country that bear any similarities to Mr. Combs' case, the defendants were released pending sentencing. Second, Mr. Combs' conditions of confinement in the MDC qualify as exceptional circumstances under the United States v. Chavez. To be released on condition under Section 3145C, two conditions must be met. First, the district court must find by clear and convincing evidence that the person is not likely to flee or pose a danger to the safety of any person or community if released. Second, it must be clearly shown that there are exceptional reasons why such person detention would not be appropriate. We will first address the exceptional reasons justifying Mr. Combs' release and then turn to the set proposed conditions that will assure Mr. Combs' return to the court and ensure the safety of the community. As noted, there are several exceptional justifying reasons for release. First, in the history of the statute, the Mann Act has never been applied to facts similar to these to prosecute or incarcerate any other person. Second, in any somewhat similarly situated case to this one, all the defendants were released pending sentencing. Third, under Chavez, Mr. Combs' conditions of confinement at the MDC for the past 11 months justify release. So essentially what they're saying is there are no similar cases as unique as the Diddy case, where he literally, only thing he did was pay for his women to get service by a SMEX worker. So they are literally telling the judge there is no case law that is out. This will be the first time this has ever happened under the Mann Act. Nobody else. We are the first and the only. Therefore, it's unique because X has changed over time. People are freaky, Judge. They just freaky like that. As Judge Furman noted in Chavez, the Supreme Court has never addressed the meaning of the exceptional reasons provision, and the Second Circuit has addressed it only sparingly. I'm going to save y'all the boring statutes because, no. The Chavez decision further noted that the circuit only published decision addressing the meaning of exceptional reasons. There are district courts found exceptional circumstances because the defendant was a student enrolled in community college, was employed full-time, and had no prior convictions. The Court of Appeals found this was a clearly erroneous interpretation of exceptional reasons, noting that the test under the section is necessarily inflexible and a flexible one. And district courts have wide latitude to determine whether a particular set of circumstances qualify as exceptional. The Court of Appeals found, however, that there was nothing exceptional about attending school or being a first-time offender. In the unpublished decision, the United States v. Colon, the court observed supporting one's family being employed and comply with the conditions of supervision is likewise not exceptional reasons to release. So they're basically trying to dumb this down. Like, that's not us. It's not us. We are different. We are DT. We have monies and connections and ties and all of these things. So let's go ahead and go to the next one because that part is just logistics. The prosecution and continued incarceration of Sean Combs are unique in history of the Mann Act. There has literally never been a case like this one. What did I just say? You know what? I may be a psychic. I might be Lou the psychic. Like Cleo, I might be Lou the psychic because I ain't even know this had said that. I ain't even read this. So you see how I saw what they was putting down before they put it down? Lou the psychic. Pay me. I'm going to put my cash app. There go my cash app right there so I can read y'all future. There has literally never been a case like this one where a person and his girlfriend arranged for an adult man to have consensual relations with the adult longtime girlfriend as a part of demonstrated swingers lifestyle and has been prosecuted and incarcerated under the Mann Act. Combs and two of his long-term girlfriends had a private intimate life that is not uncommon today. It may not have been common in June 25th, 1910, when the Mann Act, or when it was originally called the White Slave Traffic Act. Don't fucking play with us. You could have left that shit up out of there. Fuck. That just pissed me off. Was passed, but attitudes about X and morality have come a long way in the last 115 years. I agree. It is worth noting that when the Mann Act was passed to protect the morals and decency of American women, America's women were not allowed to vote, as noted below, perhaps due to the troubling background of the statute, whose history is rich in both racism and misogyny. No, it's not rich in racism, is it? I ain't see that. I know y'all ain't see that either. As noted, perhaps due to the troubling background of the statute, the Department of Justice has limited its application to those people profiting financially from the business of pros and not using it for prosecution of consensual adults for their own lifestyle. So essentially he's saying, you know what? We told you Diddy was freaky. We told you he liked to watch his girls with sex workers. That doesn't mean he profited or participated. Sir, but don't play in this judge face. Don't play in this judge face with this bullshit. You know, why is Diddy and his team playing with this judge? They know exactly what this is. They know this man participated. They know during certain occasions he was in the hole and they was in the other hole, using holes at the same time. We're not even gonna get on the fact that he liked to take that stuff back there and rub it on himself. We're not even gonna get on the fact that previous sex worker that came out that is suing both him and Cassie said that he believed that this man was trying to take it there, showing him his. So miss us with that bullshit, okay? Y'all, if be fucking for real was a person, is not Diddy and his team, but it's okay because that's what they gotta do what they gotta do. So what he essentially goes on to say is Cassie Ventura and Sean Combs went to swingers clubs and they had threesomes. Miss Ventura consistently expressed interest and enthusiasm in her intimate life with Combs. This right here is going to piss that judge off. It's going to piss the judge off. When Jane and Combs watched pornography together, Jane testified that she contacted two different porn and invited them to join her and Mr. Combs. Both Miss Ventura and Jane testified that they often would see the same men over and over and over again for years. In July of 2024, Jane Doe testified, for instance, that she suggested that Mr. Combs that they call Paul. Jane explained that she told Combs she missed Paul. When asked why she said that, she responded, "Because I did." This was a lifestyle, one that both Miss Ventura and Jane chose. Okay. One they all, as grown adults, had rights to choose. Like many aspects of of X and intimacy. It wasn't without its complications, its bouts of jealousy, and times when it was frustration. But that is a hallmark of any serious romantic relationship, and that is what these were: serious, long-term romantic relationships. But let's be clear, they left out the fact that Paul said that he ain't know Jane Doe as a girlfriend. So now you want to label her as a girlfriend because it's convenient. Mm-hmm. In the lifestyle that he and other adults voluntarily chose, Mr. Combs would be called a swinger. But in the vocabulary of the Mann Act or of prostitution, generally, he might at worst be somewhat analogous to a John. You know what a John is? Somehow, or someone who pays to have X with X workers. In this case, a male X worker, more particularly a male X worker who works for and is vetted by well-known agencies called Cowboys for Angels or another similar agency, or who works as a paying porn star in connection with movies. Sean Combs should not be in jail for this conduct. In fact, he may be the only person currently in the United States jail for being any sort of a John, and certainly the one person in jail for hiring adult male escorts for him and his girlfriend, when he did not even have X with the escort himself. Over the last 75 years, that act has been limited to defendants who cause interstate travel for financial gain through the business of pros, as reflected in the case brought under the statute, as well as the explicit enforcement policies set out in the United States Attorney Manual, more recently called the Justice Manual, that Sean Combs remained in jail for being convicted of being a customer of consensual adult X services make this case truly exceptional under the section. Not only is prosecuting the users of adult pros services inconsistent with the Mann Act, it's inconsistent with the prosecution's policies of the district attorneys of Manhattan and the city attorney of Los Angeles, California, two of these locations where the pros allegedly took place. In addition, Mr. Combs is incarcerated while everyone else involved in identical conduct, his girlfriend, the Cowboys, the agency leaders, the Orange Stars and others walk free as they should. If there was ever a fact pattern that was exceptional under the Mann Act, it's this one. As a result, this court should release him on a reasonable conditions advance of sentencing scheduled for October 3rd, 2025. This is fundamental factual distinction between the current case and scores of other Mann Act cases. And pros cases make this case exceptionally unique under the law. So, listen, I agree to a certain extent. I agree that this case is very unique. I agree that this case has never been tried. I said this, a Freaky Rico has never been tried. No one is doubting that. However, because it's so unique and you want the court to now conform to the uniqueness because it's fitting, but you don't want the court to essentially say, oh, it is unique. It's never been done before. That's why we have to treat it as such, because the way X is evolving, we have to evolve with the X. So you want us to dial it back? No, we're going to push it forward because you brought it to our attention. Now we got to treat it as advanced as you want us to. That's the reason why we're going to keep him in custody. So I took it up on myself to do a breakdown because I'm like, listen, I am not about to have y'all confused. Because, you know, we don't do confusion over here at the Public Opinion Court. We do clarity. We get Windex. We get Windex. So let's go over essentially what they're saying. Here are their legal arguments. Their legal arguments, as we discussed, is exceptional circumstances under the Mann Act. Combs is the only person currently incarcerated under the Mann Act as a non-profiter, John. I stated that. He has been acquitted of the serious charges, found not guilty of ex-trafficking and racketeering, only convicted of 2 counts of the Mann Act. They're saying he's not a flight and that should be mitigating. The defense asserts that Combs is not a flight. He proposes a $50 million bond, secure bond, passport surrender, and limited travel to the Southern District of Florida and New York. Hell no. You ain't finna get out and be able to travel. You finna sit your ass in New York where you where we can see you. And we're gonna put some agents outside of your room every freaking day so we can know you not out here trying to get your ED off. Since you've been locked up and putting that thing on rest because it needed some rest out here working that thing to death. No wonder it's backfiring. Dangerous to the community. Defense argues that the past violence was provoked and does not establish an ongoing danger. Harsh detention conditions. He like it's just so bad in there. Who gives a rat's motherfucker? It was bad in how you left them damn rooms. Had the people cleaning up behind your little nasty self. They proposed $50 million bond secured by his Miami estates, passport surrender, travel restricted to hell no, you're not going. You're not, no. Possible home confinement, electronic monitoring, and third-party custodian. Why would you think we're gonna let you sit at home when that's where y'all be doing y'all little nasty stuff at? No. So y'all remember when I went over the sentencing guidelines, and when you look at the severity of the case, that will tell you how an individual is going to be graded. So with that, I don't think he getting out. That's just but we're going to keep going. We're going to keep going. Now, here's some of the strategic insight that I picked up on. Defense is leaning heavily on the forward-thinking interpretation of how X has evolved. You see how I posed what their interpretation of how X has evolved, which is true. These people out here freaky. They just freaky like that. They just some freaky people. And I'm just like, y'all just some little nasty people. However, when you throw that out there, you have to expect a rebuttal that you know what, you are right. Now we got to broaden it because it is limited. So we need to turn it up a little. But you got to throw it out. You got to throw it all out there. You got to see what's going to stick because you got to be creative. And I would say this is creative. They also underscore exceptional circumstances tied to alleged unsafe conditions. That ain't gonna buy it. They don't give a rat's ass about that because if they did, they'll be releasing people left and right. They don't care about the exceptional circumstances. You have a better shot at the forward-thinking interpretation of the Mann Act. You should let that exceptional shit up out of there. But I get it. So what happens next? Judge previously denied the bail after the verdict, and his concerns centered around on violent conduct, public threats, and no legal not just legal technicalities. So you remember when everybody swarmed in to turn in impact letters of fear, concern if he's released? The judge took that into account, because they're always going to take under the consideration of the victim. And let me tell you why Diddy did not get out. I'm going to continue to say this because he played in that judge's face. On one of our episodes, we went over exhibits that were entered early on where Diddy knew he was under federal investigation. He was communicating, his attorneys was always communicating with the feds when he was traveling and doing things that maybe selling property, which forfeiture. So he knew this, but he was continuing on to that behavior. That has always been what the judge leaned on. His behavior, when he knew he was being investigated, he was still out here doing freak off after freak off after freak off after freak off, which renders the judge no other choice but to continue to house him. That's on him. And that's why I feel like that judge is going to use that to continue to deny it. So just a summary of some of the arguments. Of course, the Mann Act violation, only it was consensual and it was not, he did not profit. Like I said, they did what they need to do. He paid them probably another $300,000 for this, $300,000 or $400,000, probably $500,000. $500,000. History of violence. He has a history of violence. Why do y'all think he don't? The application of the Mann Act as it is presented is unprecedented because it has rarely been enforced in consensual cases. He has this state, I can put up 50 million. Well, Diddy, you gonna have to come back. If I'm the judge, I'm like, nah, 150 million. Put up the 150. You ain't gonna get it back. Put it up. You want to be out so bad, and your sentencing date is on October 3rd, and I'm already gonna put you back in there. So if you want to be out for a couple of days for 150 million, I will let you out. I will. Of course, the unsafe conditions, that to me, that is out the, he's not even going to read that because, boy, sit your ass down. So all in all, they also included his sentencing guidelines. And if you're not new here and you're true here, I went over the sentencing guidelines of what the judge was going to look at, because they said that he starts off such a low grade. But what they didn't include is the aggravating and mitigating factors. So let's go ahead and rerun that topic so that I can refresh your memory as to even more reasons why he's not going to get out. Listen, y'all, we are back with another Diddy update. Yes. It's the Diddy that keeps on giving. His lawyers filed a motion to expedite his sentencing hearing. And with doing so, they had a hearing today. And let's talk about what the hearing entailed. So Diddy's original sentence date was October 3rd. Just ironically, it was on his birthday. Ain't God funny? Instead of having a blown out hearing, the parties came to an agreement that they would move it up to September 22nd. I have to listen to both sides who agreed to push it up. The judge was like, no, October 3rd. We're going to keep it on that date. Happy birthday, Diddy. Let's get into the reason why we're really here, because everybody been hollering Diddy free on 3, but y'all don't understand. Federal sentencing is different from state sentencing because there are guidelines that the judge makes the ultimate decision on what sentence he is going to impose. The judge looks at mitigating factors that are good for the defendant and aggravating factors that are bad for the defendant. I'm going to focus on the aggravating factors because when he goes before the probation officer in order to do his preliminary sentence investigation, he has to be truthful. He has to tell the truth. And we know he got a problem with doing that. everything that is aggravating that happened in his trial, the force, the threat, the fear, the coercion, the manipulation, the bribery, any kind of aggravating factor, the judge gets to look at it. Unfortunately for Diddy, this judge sat through that trial for 7 weeks and heard everything. The reason why this is not good for Diddy is because normally an individual that takes responsibility early and goes before the judge, they don't have all of that information that this particular judge has in order to make a determination of what kind of sentence he's going to impose. So everything that was used in the trial, the government is going to bring it back into sentencing, and they're going to add it up. And every level is going to increase in order to give the court a guideline to either start or finish. Before I give my predictions, this is what I base my predictions on. The evidence and testimony that came out in the court, the aggravating factors from his past that are going to come in and is accounted for. Also, his behavior in that court, in front of the judge, his behavior knowing that he was under federal investigation from March up until September, all of that is going to come in. Not to mention, they can bring in individuals to testify regarding his character and their experience with him that did not testify during the trial. So my prediction, he's going to get 10 years to run concurrent for both counts that he was convicted of. Let me tell you why. He's going to get 5 to have to serve in, and he's going to get 5 on probation. The reason why I split it up that way is because I believe that the judge is going to look at the fact that, oh, we need to monitor him because he's a free Diddy is a wild Diddy. And we need to make sure that we are actually following his rehabilitation efforts, not just what he's doing on the inside, because that's control, but what he's doing on the outside, which is not control. Now, these are just my predictions. This is what I think. Y'all let me know what your predictions are, because those aggravating factors are definitely coming in. Welcome to the Public Opinion. So, as you can see, I'm still on the side of 50-50. But like I said, this is a unique bond. I do believe that they took their time to frame their arguments. And like I said, it's a really good argument because essentially they are right. Like, y'all ain't updated shit. So y'all want us to sit up in here and y'all ain't updated this shit, but y'all want us to deal with this shit. I agree. I just don't think he's gonna get out. But I do think 150 million bond is sufficient. Give him a bond. Give it at him at 150. He want to be out for it. Diddy is trying to get out to go get him some dick or give dick or whatever. He's trying to get something because, sir, you are not going home on October 3rd. So why are you so eager to spend 30 days out for $50 million? You are not going home. So you're going to give up $50 million for 30 days when you can keep that $50 million so your kids and for you when you get out. Diddy is the worst kind of Negro. Y'all. So of course, the government is going to have an opportunity to respond. Then the judge is going to make his ruling. Like I said, October 3rd. My predictions are based on the sentencing guidelines. I put him at a minimum 28. That is pretty high. It's literally 6 years. But that's what he's done. He did it. So now that we have addressed the Freaky Rico, now it's time for us to address Mary. Because y'all know Mary been fighting with her ex-best friend, Misa Hylton. Mary and Misa been fighting. And I think Misa got Mary fucked up. Listen, anybody that was in a relationship with Diddy, let Diddy play in their face like that, your child may or may not be his because he looked like that man that passed away. So, no, girl. So with Misha and hold on, I need to change this. With Misha and Mary, Misha filed this ridiculous lawsuit because the man that she was allowing to dick her down to YN wanted to fire her, but hold on, what is going on? Oh, I put picture. The YN that wanted to fire her, she let him come back and dick her down, hypnotize her, and she coming after her best friend when you ain't even got your shit in order. Misha is the worst type of friend that you could ever find. Baby, you sue me over some dick, it's over for you. You and that dick better be good enough because you will never, ever, ever have a place in my wonderful life. Y'all, it's Rico on all these badass friends. Every bad friend in America, there needs to be a Rico, and it needs to be a mass pickup of all bad friends who lack accountability, lack responsibility, lack ethical, lack morals, lack the presence of God. Yeah, Rico on all bad friends. We're going to start with Misha. Misha is going in first. Then we're going to start with Portia Williams. She needs to go in there too. Who else do we need to add? Kanye can go up in there. LeBron can go up in there. I love LeBron, but you play with because I heard Drake had protected you from, those allegations coming out that you would. We know y'all get a free pass. We're gonna put LeBron in there because he was dancing a little too hard to that song. That song, Not Like Us, does not require that kind of dancing. It don't. Who else we gonna put in there? That been beefing. We gonna put Ray J in there. We gonna throw the whole Zeus Network in there. We gonna go throw Candace Owens in there. Let's see, who else? We gonna throw Rick Ross in there for coming for 85 Style. We definitely gonna throw 50 Cent in there. He gonna be in one by himself. Oh, who else can we throw in there? Let me see, y'all. Let me see who else can we throw up in there because we gonna throw Dr. Cheyenne Bryant, baby. She got to go. All that capping she was doing about them relationship up here lying these people face. She got to go. We throwing her in there. So that's my list for right now. We're gonna continue to add on to that list. If y'all got a list, put it in the chat. Create your own list that we're gonna throw these Ricos on these bad friends because they need to be locked up. Just like Misha. So let's get into the overall summary of the lawsuit. So Misa filed a lawsuit in April 2025 accusing Mary J. Blige of inducing rapper VADO to breach or terminate a valid management contract with Hylton's company, Misa Management. Hylton claims that this interference not only violated contractual obligations, but also prevented VADO from earning tour income. The lawsuit seeks $5 million in damages. Let me tell you something. Before you go filing a lawsuit, make sure your fucking house is clean, Misa. Because the way she just exposed all these damn roaches running up in and out your house because you ain't got your shit together. And I ain't mean roaches literally. I mean like her business shit ain't together. So here is Mary's response. Shout out to Mary lawyers because they ate real good. They ate one of the most expensive steaks, and they're gonna get paid back for it by Misa's attorneys. Misa, who probably I ain't gonna go there. Mary J. Blige formally responded to the lawsuit on or about July 29th. She asked for a full dismissal on all claims and monetary sanctions against Hylton and her attorney. Her legal team labeled the lawsuit as patently frivolous, and meritless, alleging it was filed solely to harass and damage Blige's reputation. She challenges the legal standing. In her response, she argued that Misa Management is not a valid legal entity. According to the defense, it is neither incorporated nor licensed as a talent management firm, which undermines Hylton's ability to enforce a contract through the court. Let me go ahead and break this down to y'all. So essentially what Misa is doing, she's out here operating like she got a fucking DBA. And we know, and she ain't even got a DBA. She ain't got nothing, but that's what I want y'all to put y'all brain around. She has never formed this entity in this state where she has filed this lawsuit. So essentially, she cannot say that she, as an entity, was harmed. She can say her personally, but not an entity. But she's already jumped in that motherfucking water, and that water was hot. It wasn't cold. It wasn't lukewarm. It was hot. And now she has third-degree burns. So suing under an entity when you don't have an entity to sue under the state that you have stated that you are formed in is a fucking rookie mistake. So I'm actually put this on her lawyers because her lawyers should have went to the state, the Secretary of State in New York, to make sure she had an entity and it was active. She didn't have no, it wasn't forfeited. Because maybe that's what happened. Maybe it has been forfeited. Maybe she didn't pay her taxes. Maybe she didn't renew. That could very well be true. But you got to do that. Like when you are suing another business under your client's business, go and check the Secretary of State. You're going to see if it's active or not. I can tell you, one of my clients in the past was in a dispute over ownership of something I'm not going to name. I went to check the Secretary of State. Not active. So you know what I did? I sent a response. Count your mother days. And they went away. So the evidence, Blige's legal team submitted a text message, y'all. This is so petty, but I just love Auntie. Even though she don't want to be called Auntie, baby. You are Auntie. Auntie Blige. That was sent by VADO to Blige that stated, between me and you, I might be firing Misa. So how was she stealing something that didn't even want you? Y'all was beefing. You did something to piss him off. He did something to piss you off. Instead of y'all playing the personal things separate from the business, y'all commingled. Because why are you sleeping with your client? That's a conflict of interest. You're not supposed to be sleeping with your client because let me tell you something. Your client can go and file sexual harassment against you because you ain't supposed to be sleeping with your client. But that she wanted her YN. She wanted her YN. Mm-hmm. But she ain't want us to know that she was getting her back broke by a YN who was gonna fire her. And then Mary was like, are you sure you might want to talk to her before you do that? She tried to talk him off the ledge, but you out here suing your girl. You should have asked for them text messages, Misa. Don't be an old lady. Only time you want to act young when you get them pipes burst. Girl, The messages was used to argue that VADO intended to terminate Hylton on his own accord, not due to Blige's influence, because in the lawsuit that she originally filed, she stated that Mary was trying to influence him. So here's what her attorney sent. Plaintiff and their counsel appear to enjoy fabricated accusations that will be discussed in the press and on social media for the purposes of harassing defendant and trying to coerce a favorable settlement. It is obvious that the complaint was filed by you and plaintiffs for the sole purposes of harassing and causing malicious injury to Beautiful Life and Ms. Blige based on Hylton's personal issues. The complaint lacks factual and legal merit, and it is clear that this lawsuit was not brought in good faith. I agree, because if you ain't even an entity, that ain't no fucking good faith. Your client has had substantial time to review the facts, including our prior detailed correspondence that outline why each claim was without merit. Nevertheless, you and your client chose to proceed with filing a baseless complaint, knowing full well the legal deficiencies involved. Your next step is handling this matter. Hold on, they ate with this. Your next step in handling this matter shall govern ours. Should you fail to voluntarily dismiss the complaint, we will proceed with our next step to ask the court for sanctions against you and your client. So what sanctions are is when the judge can penalize you and make you pay opposing counsel whatever fee they find that is reasonable. And in this case, it may be about $25,000 at minimum. Because y'all know y'all fucking wrong. Make sure your lawsuit has merit. Actually, make sure you can sue in that state under that entity. That would be a start. So they sent over the text messages, screenshots of VADO. But they didn't budge when they sent them this letter. So that is why they are currently in the news today. I believe that Mary is going to be victorious. I believe that she has all the ingredients to kick Misa's ass. Misa, let that dick go. That young man got you so twisted because he is knocking out them old cobwebs and sewing up that old used vagina and making you feel brand new. But you sued your girl. You can't be trusted. You became stigmatized and you sued your girl when your man was gonna terminate you and didn't nobody even have to ask him that. Be fucking for real, Misa. I am going to say Mary is going to win this, and she's going to win this with without it going to court, because the judge will dismiss it. It's going to be dismissed off of the entity status in itself. And then if I'm Mary, I'm going to freaking counter and sue your ass personally and take all your shit. Because now you have pierced the corporate veil. You have pierced the corporate veil, Miss Misa. Now we can come after your business and your personal assets. Y'all had to pull my moo out today for my auntie and listen, because the auntie don't play with our auntie Mary. So that's what I have for y'all today. Let me just say this. Make sure y'all liking and subscribing. Make sure that you are following the Public Opinion Court, because we also post shorts. I've been posting shorts consistently every day with breaking news. And if you don't gonna miss it, listen, that's on you. But I had to break this down. We're going to get back to the regular scheduled program. We got some more breaking news that is coming. It's just been so much been happening in the news, y'all, that we're going to get to. But I wanted to hit y'all with that. And as always, the Public Opinion Court is where what? The truth ain't reality. But what is? What's the reality? Opinions.